The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your host, Anthony Sanders, Director of the Center for Judicial Engagement at the Institute for Justice. We have a packed show today, so let's get right to it. Joining me in the virtual studio are Michael Bindas and Diana Simpson, both IJ attorneys. Welcome to both of you.
Thank you, Anthony.
Thanks for having us, Anthony.
Well, both of them will have an interesting federal court of appeals case to talk about later. But an even more interesting thing is that Michael has just finished briefing a cert petition to the U.S. Supreme Court from the Ninth Circuit, and he's joining us to talk a bit about that before we get to our usual format. And this is a case that many listeners may recognize. Michael and IJ have been litigating this case for, I believe, 9.5 years now. And it concerns our old friend, the Privileges or Immunities Clause of the 14th Amendment. So, Michael, tell us what's going on with our privileges or immunities.
Sure. Thanks, Anthony. This case, as Anthony mentions, is nearly a decade in the making, at least just in terms of litigation, but it's really almost a quarter century in the making because it involves two brothers, Jim and Cliff Courtney, who since 1997 have been trying to provide some form of boat transportation on Lake Chelan. Now, Lake Chelan is a 55-mile-long lake in Washington state. And Jim and Cliff live at the far end of the lake in a very remote community called Stehekin. And Stehekin's only accessible by a very long hike or by boat or float plane. And Jim and Cliff, along with their family, have several businesses in Stehekin. And they've long sought to increase access to Stehekin and to their family's businesses. And so they've been trying to provide, since 1997, everything from a full-blown public ferry on the lake to shuttle folks back to and from Stehekin, or something as simple as just shuttling customers of their own businesses to increase the accessibility to their own business. But they've been thwarted at every turn by an anti-competitive state licensing law known as a public convenience and necessity requirement. Basically, Washington state prohibits anybody from operating any form of boat transportation on Lake Chelan unless the existing incumbent ferry provider consents to this service, or the would-be boat transportation provider proves to the government in a trial, basically, that their transportation is necessary for the public convenience. That is problematic in our view, and so we filed a lawsuit on behalf of the Courtneys back in 2011. Challenging this anti-competitive licensing law, and we challenged it under, as Anthony, you mentioned, the Privileges or Immunities Clause of the 14th Amendment. And at this point, listeners out there are probably saying, "Come on, that's ridiculous. Everybody knows the Privileges or Immunities Clause is dead." Akil Amar famously said that the slaughterhouse cases, which were decided just 5 years after the Privileges or Immunities Clause was ratified, strangled the clause in the crib. And there's something to that. Slaughterhouse was a horrible opinion, and it really restricted the scope of the Privileges or Immunities Clause. But Slaughterhouse also recognized a handful of rights that the clause does in fact protect. And one of those rights is the right to use the navigable waters of the United States. Lo and behold, that's the very right that Jim and Cliff Courtney seek to exercise on Lake Chelan. Lake Chelan is a navigable water of the United States. In fact, the federal government has designated it a navigable water of the United States, and they wish to use that water to shuttle customers to and from their businesses. So we challenged the public convenience and necessity requirement as an infringement on their right to use the navigable waters. Back in 2013, the Ninth Circuit held that, whatever the Privileges or Immunities Clause protects, whatever this right to use the navigable waters is, it's surely not the right to operate a full-blown public ferry, because that has traditionally been the prerogative of the states, and surely states can limit who provides public ferry service. We thought that decision was wrong, but that disposed of kind of that portion of the case. But even if the Ninth Circuit is right that the clause prohibits or doesn't protect the operation of a full-blown public ferry, the Courtneys still believe it protects their right to at least transport customers to and from their own business. So after that first ruling from the Ninth Circuit about public ferries, we pressed on with our second argument, which was that the right to use the navigable waters at least protects their right to shuttle their own customers to and from their own business. And earlier this year, the Ninth Circuit, unfortunately, held that the right does not protect that, and that therefore the Courtneys could not state a Privileges or Immunities Clause claim. Basically, the Ninth Circuit said that this right to use the navigable waters is only a right to use the navigable waters in interstate commerce, and since the Courtneys would be traveling wholly within Washington state, their transportation is not protected. And worse, the Ninth Circuit went so far as to hold that the Privileges or Immunities Clause generally bars claims against a citizen's own state. And since the Courtneys' beef was with Washington state, they have no recourse under the Privileges or Immunities Clause, which just flies in the face of everything that everyone agrees about when it comes to the Privileges or Immunities Clause, which is that it was meant in large part to protect the freedmen in the wake of the Civil War from abuses at the hands of their own southern state governments.
And that's not, Michael, sorry to interrupt, but that's not something that like Slaughterhouse intimates or even a couple more modern cases intimate. That's just completely weirdly out of left field what the Ninth Circuit said there.
It's out of left field in one respect and in just how bizarre it is and inconsistent with the history of the Privileges or Immunities Clause. But the way the Ninth Circuit got there is really disturbing. The Ninth Circuit, in reaching that conclusion, conflated the Privileges and Immunities Clause of Article 4, Section 2, sometimes called the Comity Clause, with the Privileges or Immunities Clause of the 14th Amendment. And when it comes to the former, the Privileges and Immunities Clause, that clause does not protect you from your own state. It is meant to protect citizens who are temporarily in other states, and therefore that clause correctly is limited to the to claims against a state other than your own. But that's not the clause at issue in this case. This case involves the Privileges or Immunities Clause. And the Ninth Circuit just botched it. And it's done that twice now. It did it first in a case called Merrifield back in the early 2000s. And it relied on Merrifield in this case to, again, kind of double down on this notion that the Privileges or Immunities Clause does not protect you from your own state. And again, that just flies in the face of the history of the Privileges or Immunities Clause. It also flies in the face of two U.S. Supreme Court decisions. Most recently, a case called Sines versus Roe. The Supreme Court expressly held that the Privileges or Immunities Clause does protect you against your own state. So the Ninth Circuit just got it wrong. It botched the analysis here. It confused two constitutional provisions. And that sure sounds like a reason for the Supreme Court to take this case and correct that decision. And that's, even apart from this other holding that the right to use the navigable waters, a right that the Supreme Court expressly recognized as protected by the clause, is somehow only limited to traveling between your state and another, or your state and a foreign country. Clearly, that right applies even when you're traveling within your own state.
And so the case is fully briefed before the court now. And how many amicus briefs were filed in the case?
We received 3 amicus briefs, and they're fascinating. One of them is on behalf of a group of law professors who really take the Ninth Circuit to task for this notion that the Privileges or Immunities Clause doesn't protect you against your own state. Another one was by a group of historians who have done a lot of historical work on the importance of the right to use the navigable waters to the freedmen in the wake of the Civil War. This was a vitally important right to them, that it was very common for the freedmen to earn a living in maritime pursuits, other trades on the water. And it was also very common for Southern governments to restrict their ability to engage in these economic pursuits on the navigable waters. So it's a really fascinating brief that informs just what it meant to use the navigable waters at the time the 14th Amendment was ratified. And then we also received another brief from Americans for Prosperity Foundation, which focuses on the origins of the right to use the navigable waters, which is, again, a fascinating issue. It's a right that dates back to Magna Carta, believe it or not, that was protected in English common law around the time of our framing, and that was memorialized in the Northwest Ordinance, which is part of the very organic law of our nation. So this is a storied right, one that dates back centuries, and one you would certainly hope is worth the Supreme Court protecting here.
Well, I understand the case is it hasn't been scheduled for conference yet, but it's going to conference next month, probably.
That's right. It should, barring anything unforeseen, it should go to conference on January 8th. So it's conceivable that sometime in early to mid-January, we could hear something one way or the other about the court taking it up.
Great. Well, we're recording this, I should have said, on December 22nd. So maybe just a few weeks from now, we'll know the fate of this cert petition. It's always a fun feeling having a cert petition sit on the docket of the U.S. Supreme Court. I'm waiting to what will happen. I know Diana has been through that experience.
Very anxiety-producing feeling.
I say fun in quotation marks there, of course. Let's get away from that anxiety and to a different kind of anxiety, and that's recording the police. So, Diana, tell us how that has come down in the state of Massachusetts.
Yeah, so we've got a case today out of the First Circuit. As one of the few courts to use Courier as its font, which is something I always feel is worth mentioning because it makes my eyes bleed a little bit.
We should do an episode on fonts of the circuits. I was thinking that because
the Fifth Circuit
is always
they use
a
equity.
problem.
The Fifth Circuit uses equity, and it's beautiful. They've recently come back around to this, but I suppose we could have that conversation a different day rather than go from these like big picture questions about the rights of the Privileges or Immunities Clause and contrast to the Privileges and Immunities Clause to then just talking about fonts. Well, I'll shift back to the First Circuit here. And so we've got a case coming out of Massachusetts. And this case is about a law that was passed over 50 years ago called Section 99. And Section 99 makes it a crime for any person to willfully commit an interception of any wire or oral communication. And so basically, what that means is that it is illegal in Massachusetts to secretly record the contents of a communication. So if people are talking outside and they can't see that you are recording them, you can't record them. And so about 8 years after the law was first passed, the Massachusetts High Court, in a case called Jackson, interpreted the law to say that a recording was made secretly if the person being recorded doesn't have actual knowledge of the recording. And so that sweeps pretty broadly because that means that if other people know that you're recording them, it doesn't matter. The one person whose knowledge is important is the person being recorded. And so in that case, that Jackson case in 1976, the Massachusetts High Court upheld the statute and said that audio recordings of a kidnapper's ransom calls violated the law, even if the person had no reasonable expectation of privacy in that communication. And then in 2001, in a case called Hyde, the Massachusetts High Court again upheld Section 99. And it said that it did not impliedly exempt recordings of police who are lacking an expectation of privacy. And so that case came out of a prosecution for a guy who had recorded the audio of a traffic stop without the officer's knowledge. And so the court said, that's perfectly illegal under this law. And so what people should do is just announce their recording before it starts. And so, this was 19 years ago. And so this case, there's actually two cases at issue here. There's a case brought by the Martin plaintiffs and a case brought by Project Veritas. And so the First Circuit hears these cases together. And these cases are very modern in contrast to the origins of the law and in contrast to kind of this historical understanding or interpretation of what the law means and what it's meant to do when, some of these recording devices were a little bit different than they are today, where now today everyone's got, a camera in their hand and they can broadcast it to literally millions of people as something is going down. But anyway, so the Martin plaintiffs were a group of civil rights activists who brought a DEC action, a declaratory judgment action, saying that they want to record police officers without their consent as the police officers are discharging their official duties in public. Massachusetts still enforces the statute, and the Boston Police Department training materials tell police that they can arrest people for secretly recording cops who are performing their duties in public. So the Martin plaintiffs won below at the trial court. They had the district court say that this was unconstitutional, that it failed intermediate scrutiny. And so the police did not appeal that decision, but the district attorney of Massachusetts did. So you've got that case. I've set that one up. But then now we've also got the Project Veritas case and those plaintiffs. And so that one's a little bit different. And that one was also a DEC action. And basically it boils down to kind of a group that wants to record people, any people, not just police, but any person who is lacking the reasonable expectation of privacy in what is being recorded. And they also want to record all government officials, not just police, but any government official anywhere, discharging their duties in public spaces. And so they were a little bit less successful below. But so they appealed, and the DA in the other case, in the Martin case, appealed, and the First Circuit heard these all together. And the First Circuit it addressed the Martin plaintiffs first, and it spends 14 pages going through explaining why the Martin plaintiffs have standing to pursue this case. And I gotta say, it is exhausting having to read through these 14 pages on standing, because people are not, there's this whole line of case law saying that people do not have to risk enforcement first before they can challenge, particularly when it comes to the First Amendment. And yet it's, they had to go through a lot to just convince the court here that they had standing, that they were at risk from the statute, that they record the police in all other states, and they want to record the police in Massachusetts, but they can't, given that this statute exists and it's still being enforced. And so it's exhausting just in terms of being a constitutional litigator and bringing these kinds of cases, like thinking through exactly what you have to do to establish standing. But it's also exhausting just thinking about what you have to do to just participate in society and record these kinds of things and engage in this kind of activity, and challenge statutes that you think are unconstitutional before they're applied to you and before you risk having to go to jail for them. But put that to the side. The First Circuit ends up saying that the First Amendment applies to recording the police because this is gathering information, and this is well within the protection of the First Amendment. And so the court points to a bunch of other courts of appeals decisions, and not one of them has said that the First Amendment does not protect the right to record police. Some of them, at least, have held that it was not clearly established for qualified immunity purposes, which the Third Circuit did in 2010, but none of them have said that there isn't this right or that it's not protected at all. And so then the court goes on and says that there's actually a lot of benefit to secretly recording the police, and that this undetected recording can itself serve a cardinal First Amendment interest in protecting and promoting the free discussion of governmental affairs, so that it can be even more important than open recording. Because the police may not know, they won't be disrupted, and it clearly shows what's going on. And so the First Amendment applies. What standard of review? You get an intermediate scrutiny, and this law fails intermediate scrutiny because it just sweeps far too broadly. It prohibits all kinds of recording, even though there are lots of places where this kind of recording can come in handy and can be really important. And I think, everyone in this country saw just how important police recordings are and can be. And by police recordings, I mean recordings of police that they themselves are not necessarily taking. Look at this past summer. So the Martin plaintiffs win, and it's, this great announcement of the ability to record the police in public without the police's knowledge. The opinion then shifts to the Project Veritas appeal, and they do not fare as well. And so they raise this facial overbreadth challenge that they did not succeed at because basically, they did not point to enough unconstitutional applications of the law to show that it was substantial compared to the constitutional applications. And basically, what that just means is that they didn't point out enough times where it would be unconstitutional, and this standard for facial overbreadth is just exceedingly broad and very challenging to beat.
And is that, Diane, because they talked about how it applies to people other than government officials? And because there's so many non-government officials out there, it's kind of like overwhelms the math.
Yeah, and it's just, there are applications of this law where, it would be constitutional. And I think the opinion said that Project Veritas had provided 10 different examples where there was unconstitutional. Okay, but then there's a lot more than 10 where it is constitutional. And so if it's a simple math equation, 10 is not substantial compared to more than 10. And so that ends up being a tough standard to beat. But then the court moves on to kind of the last two arguments that are not facial overbreadth, but that are kind of more of the traditional First Amendment analysis that the Martin case talked about, or the Martin portion of the case talked about, and some of the others. And this was the ability to secretly record anyone lacking a reasonable expectation of privacy in what's being recorded, and the ability to secretly record all government officials to start discharging any of their duties in a public space. And the court basically kicks it and says that the issue isn't ripe because it just isn't clear exactly what they want to challenge, who has a reasonable expectation of privacy, and what the edges of the case are, particularly considering the breadth of the remedy sought. And so it's interesting kind of seeing how the court shifts from this Martin portion of the case where, I think they really fully embrace the First Amendment and exactly one of the strongest places that it can be used. And then this other portion of the decision where, you haven't explained exactly what you mean by government officials. That doesn't just include the police, but that also includes teachers and, the DMV and, anybody else. And so what kinds of recordings are you going to do? Well, you can't tell us clearly. And so we're just not going to reach the decision. And so it's just interesting to me to see kind of the difference between those two.
And what the bottom line, it seems to me, is that if you're in Massachusetts now because of this ruling and you see the police, you can record them secretly.
Yes.
It's not like it's only a small segment of when you see the police.
So I say yes. This was a big portion of the case. I mean, this is a long decision. This is a 72-page opinion. And so because it's in Courier, it takes a little bit less space than, one of the others might. But they spend a lot of time talking about the difference between facial and as-applied relief, because the plaintiffs here were asking for a declaration that this that Section 99 was illegal when it applied to the recording of police discharging their duties. Well, so that's only a portion of the statute. You're not challenging the whole statute. So is that an as-applied claim? Well, no, it's facial because you're not just looking for relief for you. You're looking for relief for anyone trying to record the police. And so basically the upshot is that recording the police who are discharging their official duties in public, you're probably fine to go ahead and record them without the police officer's knowledge. Of course, you can't get in the way. You can't be right in the middle with your camera phone up in their face while they're trying to do something. But that's at least protected by the First Amendment now.
Yeah, I would say if people are interested or have been confused in the past about the whole facial as-applied distinction, and there is literally no one who studies this issue who is not confused by it, the case does a really good job, I think, of drilling down into how that works in these circumstances where you're challenging part of a statute, not the whole statute, or you're challenging a statute as applied to a certain type of situation, but it's not just as applied to this one thing that this one person did, right? So there's a continuum between something happened to someone in one set of circumstances, and so they're trying to have the law declared unconstitutional as applied to that one person in that one circumstance. And then all the other side is that the whole entire law is facially unconstitutional. And courts often get very confused as to what all that middle is. And there's a lot of middle there. And this court actually tries to dig into what that means. Now, what the standard is for as applied versus facial is still messed up and probably will be messed up for some time to come. But the court at least tries to grapple with it. One other thing I thought about this opinion, and you, I think, were kindly intimating it earlier, Diana, is that they did spend a lot of time on standing. They spent a lot of time on a lot of other issues. I don't know if God bless his or her heart, whoever the clerk was who drafted this opinion, I don't know if that person needed to spend as much time on all of the issues in all 72 pages in Courier font. And I would just encourage all those good clerks out there writing opinions that, there is some value in brevity. And man, this opinion really drilled down into a lot of issues. But, to be remembered for posterity, it helps to say things in fewer words sometimes.
Indeed. It certainly will be helpful to be cited. And, if you're looking up standing issues, that'll certainly kind of come to the forefront here. One thing I neglected to mention at the beginning was the makeup of the panel. Our friend Judge Celia was on it, but he did not write it, as evidenced by the lack of vocabulary words in it. Judge Barron wrote it, and Justice Souter was also on the panel, sitting by designation, of course. So that was an interesting trio, I thought.
That's right. Well, there was a different trio with an interesting guest also in the Ninth Circuit in a case that Michael's going to tell us about.
Yeah, much shorter case, opinion-wise, but no less important than the one Diana just discussed, and it's Calvary Chapel, Dayton Valley versus Sisolak. And this case stems from Governor Sisolak, governor of Nevada, one of the directives that he issued early on during the COVID epidemic. It limited indoor activities in different ways. With respect to indoor religious services, it imposed a 50-person cap on attendance at indoor religious services. But it allowed such establishments as casinos, gyms, bowling alleys, retail businesses to have up to 50% of their capacity, their fire code occupancy. And so you had, this disparate treatment where indoor religious services were treated more restrictively than all of these other types of businesses and establishments. And so Calvary Chapel challenged that restriction under the Free Exercise Clause, arguing that it was not a neutral or generally applicable law because it targeted indoor religious services for more harsh treatment relative to these other types of establishments. And the governor, in turn, defended the law, saying that it was a permissible response to the COVID epidemic, pointing to Jacobson versus Massachusetts, which is a case I think has come up in some recent episodes of Short Circuit concerning government's powers during the smallpox epidemic in the early 20th century. And the court, federal district court, initially denied the request of Calvary Chapel for a preliminary injunction in the case. And Calvary Chapel appealed that decision up to the Ninth Circuit. And while the case was on appeal, given that it was going to take some time to play out, Calvary Chapel actually asked for an emergency injunction pending the duration of the appeal. The Ninth Circuit denied that. The Supreme Court denied a subsequent request for this emergency injunction. But Calvary Chapel then asked the Supreme Court to take the case up, grant certiorari even before judgment had been entered by the Ninth Circuit. While that was still kind of lingering out there, the Ninth Circuit actually got around to issuing its opinion on the preliminary injunction. And it reversed that decision in light of a recent decision from the Supreme Court on another governor's COVID response directive. That was Governor Cuomo's order in New York that imposed similar restrictions, a bit more severe on places of worship in some parts of New York. And the Supreme Court in that case, the Roman Catholic Diocese of Brooklyn, versus Cuomo.
Otherwise known, I believe, as the case that ruined every First Amendment scholar's Thanksgiving Eve this year. It came out about, 9 p.m. Thanksgiving Eve, I think.
Yes, but it was a perfect timing, Thanksgiving-wise, from the church's perspective and from the First Amendment's perspective. And in that case, the Supreme Court, in light of the kind of disparate treatment of churches relative to other establishments, such as garages, acupuncturists, the many other types of businesses that were treated more favorably than religion, the Supreme Court enjoined enforcement of Governor Cuomo's order. So in light of that November 2020 decision from the Supreme Court, the Ninth Circuit in the Nevada case held that the preliminary injunction was in fact warranted because the Nevada order, the Governor Sisolak's order, like Governor Cuomo's order, treated religious entities worse off than their secular counterparts, and that presented a free exercise problem. It's a fascinating case, too, for a couple of reasons that deal with judicial engagement generally. Number one, there's a great line in the Ninth Circuit's opinion where the court acknowledges that the judges are not public health experts and that they certainly have to defer to public health experts in terms of appropriate ways for dealing with the pandemic, but nevertheless, in the Ninth Circuit's words, the Constitution cannot be put away and forgotten in a time of pandemic. So, the court acknowledging that simply because there is this public health crisis at the moment doesn't mean that judges can turn a blind eye to the Constitution and the restrictions that it imposes on the government's response to the public health crisis. So that was encouraging to see from a judicial engagement perspective. Also, it was in both cases, in both the Nevada case and the New York case, the directives or the orders that the governors had issued had either expired or been superseded. And so the government in both cases tried to argue that the cases were moot as a result of that fact. And in both cases, the courts rejected that argument in light of the fact that these orders could very well easily be imposed again, or similar orders could be imposed again as the pandemic continues to play out. And in light of the fact that if that were the case, litigants would not have the opportunity to secure any kind of judicial review of those orders in a sufficiently timely way so as to protect their rights. And so it was very heartening to see the courts kind of reject these arguments on that the government posited to try to avoid getting a resolution of these cases on the merits. So I think these are both great cases in terms of judicial engagement, both because of their recognition that the Constitution continues to apply even in times of a public health emergency, and also insofar as they reject the government's attempt to avoid the litigants getting a decision on the merits of their claims.
Yeah, no, it's always interesting to me, and I think a lot of people who litigate against the government are perhaps familiar with the pretty standard tactic of the government fighting until they perhaps realize they're not going to be successful, and then changing stride midway, and then saying that the case is moot and that the court shouldn't address it, which just totally deprives people of the ability to defend their rights in court. And I think we've seen a lot of that. There was a case up at SCOTUS last year out of New York, which certainly resulted in a fiery opinion from Justice Alito about whether the case was moot or not and whether the court should continue to rule on it or not. And there's a case pending right now at SCOTUS about whether nominal damages are sufficient to continue a case. And all of these go back to the simple question of mootness and what that does to a case. And, once you're litigating about an issue, particularly about an issue that's been, when the government is trying to really exert its control over your life, and especially when it comes to churches and other kinds of really deep issues like that, it's heartening to see courts saying, like, no, you can't get out of it that quickly, government. You have to, we're going to address the issue, even if you don't want us to.
And if there's one thing we've learned from the last few months, whether you support a specific pandemic order or you don't, it's that these things come and go quickly, and so the numbers go down, and so things loosen up, and then all of a sudden they spike up again and they come back, and so it's really hard to argue that something really is moot, as government attorneys are arguing in these many cases. Michael, before we go, I wanted to ask you about a couple fascinating pages of the opinion in Cavalry Chapel, where so they start out when they start addressing the Roman Catholic Diocese case, the New York case. They say the Supreme Court's recent decision arguably represents a seismic shift in free exercise law and compels a result in this case. And then they talk about it for a couple paragraphs. And at the very end, and then they actually quote a famous First Amendment case, Church of Lukumi, which is about how to apply the earlier Smith case, the case about how if you have a broadly applicable law that doesn't single out religion, then it gets a different standard than if it does. And so they talk about that. And then at the very end of the paragraph, they say, but see Church of Lukumi and Smith, as in, well, yeah, that's actually the law as it's been for 30 years, but this new seismic shift case came out, and we're not exactly sure what to do with this, but we're going to apply that one. So do you see a little subtext there about whether Smith even applies in this area anymore? And, they don't know what to do because there's other cases pending at SCOTUS, or what do you make of all that?
I don't know what to make of that. I mean, surely, there's Smith's. There's been no shortage of calls for Smith to be overruled by the Supreme Court, and there are certainly vehicles by which that could happen in the near future. But at the same time, I don't see this as any kind of seismic shift in free exercise jurisprudence. I see this as a pretty straight application of Lukumi, and I don't know how to explain, the Ninth Circuit's decision. For me, really, the significance of this case is its commitment to enforcing the Constitution, even in the face of a pandemic, and its refusal to allow those circumstances to somehow tip the scales in favor of the government. But in terms of just, the fundamentals of free exercise analysis, I don't see this as the seismic sea change that the Ninth Circuit claimed it was.
Sure, and to be fair, they say arguably represented a seismic shift.
But the upshot is that you can't treat casinos better than churches. I think if you're going to put a bullet point on this case, that's got to be it.
Yes,
we finally established that as a matter of federal constitutional
if there
law.
Was any
I'm glad they answered
about
the
that.
question.
Going back to the beginning where I said there was an interesting panel in this case as well, what I was intimating, Michael, is Judge Danny Boggs from the Sixth Circuit was sitting by designation on this panel. So it's nice, of course, when we see the judges move around and see some different scenery. Well, thank you all for joining us. You may have already celebrated your holiday of choice by the time you listen to this podcast, whether that's Festivus or Happy New Year or Christmas or Kwanzaa or what have you. But we wish you a happy holidays. Stay tuned for our next episode. And in the meantime, we ask you to get engaged.